Mic check, test 1, 2, 3. Good check. Good morning. This is our microphone check for our broadcast this morning. If you are registered to speak today, please make sure that the button is on by checking the green light, yellow light that's on the microphone, and make sure you're within a speaking range onto the microphone so that we can hear you clearly. And before you leave the podium, please make sure that you push the button to mute yourself as I'm about to do right now.
Good morning and welcome to the November 19th, 2025 meeting of the Texas Commission on Environmental Quality. It is 9:31 a.m. I'm joined by my colleagues, Katarina Gonzalez and Tanya Miller, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we will inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you would like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you're on the webinar, email agenda@tcaq.texas.gov with your name, affiliation, and the item that you'd like to comment on. We will do our absolute best to accommodate the request. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking. And please, please, please make sure that your line is unmuted before proceeding. With that, Mary, I'm going to call the first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the petitions for the creation of Grayson County Municipal Utility District numbers 6A and 6B. The parties have been notified that the petitioner, protestant, ED, and OPIC will each have 5 minutes of oral argument time. The petitioner should speak first and may reserve a portion of time for rebuttal as the petitioner bears the burden of proof in this matter. And so with that, I believe we have Derek Seal here for the petitioner.
Good morning.
Good morning.
Commissioners, General Counsel, I'm Derek Seal with the law firm of McGinnis Lockridge here in Austin. I represent Treasure Island Laguna Azure LLC. We have acquired about 1,127 acres in Grayson County. We bought the property in November 2021, northeast of the city of Van Alstyne. Our purposes are to develop the property into a residential subdivision. We're planning single-family residential lots. We have multifamily housing, we have commercial establishments, we have amenities, and we have a school. As a normal part of the development process for a project of this magnitude, we petition your agency for the creation of Grayson County MUD numbers 6A and 6B. The MUDs will facilitate the orderly development, cost-effective financing, and will provide services that will be needed. Only the city of Van Alstyne objected. The briefing and the ALJ all do a great job describing what our project is, the process we followed, the evidentiary record we developed at SOA. We agree with the ALJ's evaluation that the evidence in the record shows that we've met our burden of proof, and we would ask that you grant the petitions. I know you and your general counsel have reviewed the briefing and the PFD, and I don't really have anything to add, so I'll stop there and save any of my time for rebuttal.
Thank you very much. We have Ms. Albright.
Good morning, Commissioners. My name is Stephanie Albright, and I'm with Bickerstaff Heath Delgado Acosta, and I represent the City of Van Alstyne as a protestant in this case. The applicant here is not simply asking for permission to draw boundary lines. The applicant is asking to create a new local government entity with the power to levy taxes, to fine residents, issue debt, condemn property, and to build and finance roads. To be granted the privilege to create a MUD, an applicant should, at the very least, provide a plan of development and projected costs that demonstrate that the proposed project is feasible. The applicant has not done so in this matter. The city understands that in a petition to create a MUD, plans and the cost of a proposed development might change over time. But an applicant must show at the time of the application that a proposed MUD is legally, financially, and technically feasible through the preliminary engineering report, and that the requirements of Section 54021 of the Texas Water Code have been met. The applicant has not done so in this case and has not carried his burden. First, the applicant is required to determine the reasonableness of cost at the time that the petition is submitted and the preliminary engineering report is prepared. However, the applicant's witness in this situation testified to the reasonableness of costs in the petition, but made a comparison of present-day costs versus the cost at the time of the creation of the preliminary engineering report. This analysis used the wrong cost comparisons and failed to demonstrate that the costs in the preliminary engineering report are reasonable. Further, the applicant is proposing to construct on-site water and wastewater facilities at a cost of approximately $87 million. The city's expert has testified that both that the city is willing to provide these services to the proposed districts and that would do so at significantly lower cost, with a reduction estimated to be $73 million less expensive than building the independent systems. The cost to build on-site water and wastewater system, costs that would be borne by the future residents in these districts, are not reasonable when compared to the significantly lower cost that would be borne to receive comparable service from the city. Additionally, the applicant has failed to provide any meaningful analysis regarding the impacts to groundwater levels and recharge in the region as required under Chapter 54 of the Water Code. The proposed district anticipates using 13 groundwater wells at various depths, but the applicant did not provide any study or analysis to determine whether the development will have an unreasonable effect on groundwater levels and groundwater recharge. Finally, the applicant has not shown whether the proposed project will have an unreasonable effect on the natural runoff rates and drainage in the area. The city's expert has shown that the project is only proposed to have an open space and detention on only 10% of the total land area, even though the area contains 2 FEMA floodplains. This is an insufficient amount of land to set aside to absorb stormwater runoff. It is the burden of the applicant to show that the requirements of Texas Water Code Section 54021 have been met, and the applicant in this matter has not done so. For these reasons, and for all the reasons provided in the city's closing arguments, the city urges the commission to deny the petitions to create these MUDs. Thank you.
Thank you very much. Executive Director, staff, Kayla?
Good morning, Chairwoman, Commissioners, General Counsel, and Office of Public Interest Counsel. I am Kayla Murray, an attorney in the Environmental Law Division, representing the Executive Director. With me is my co-counsel, Cole Malley, and Justin Tack, manager of the district section. In the proposals for decision, the ALJ concluded that the applicant met its burden of proving the district's creations meet all applicable statutory and regulatory requirements. The ED recommends the Commission adopt the administrative law judge's proposed orders and create Grayson County MUDs 6A and 6B. Thank you, and we are available for questions.
Thank you very much. OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, Executive Directors, Attorneys, and staff. My name is Eli Martinez. I'm Senior Attorney with the Office of Public Interest Counsel for the record. Our office participated in the contested case hearing on the consolidated petitions by petitioner Treasure Island Laguna Azura for the creation of Grayson County Municipal Utility Districts numbers 6A and B. After review of the evidence, applicable law, and the briefing submitted in this matter, OPIC recommends that the Commission approve the petitions and create the districts as proposed. Petitioner submitted 2 municipal utility district creation petitions to the TCEQ and subsequently requested consolidation and direct referral to SOA. The parties agreed the scope of the hearing was whether the petitions comply with all applicable statutory and regulatory requirements. The burden of proof in this matter is on the petitioner as the moving party to prove by preponderance of the evidence all applicable requirements under Article 16, Section 59 of the Texas Constitution, Texas Water Code, Chapters 49 and 54, and Chapter 293 of the Commission's rules. A MUD may be created for purposes of including handling, water control, storage, preservation and distribution, reclamation and irrigation, drainage, conservation of resources, navigation, abatement of water shortages or excesses, and protection of water purity and sanitary conditions. The petition must be signed by a majority and value of title holders, describe boundaries, state the general nature of work, necessity, and estimated costs. The Commission shall grant the petitions if they conform to Texas Water Code 54015 and the projects are feasible, practicable, necessary, and beneficial to the land. Factors include availability of comparable services, reasonableness of costs, tax rates and water sewer rates, and effects on land elevation, subsidence, groundwater, recharge, runoff, drainage, water quality, and total tax assessments. The Commission may exclude non-benefited land, redefine boundaries, or deny if non-conforming or not feasible, practicable, necessary, or beneficial. OPIC evaluated the evidence and concluded that the petitions comply with all requirements demonstrating feasibility, practicability, necessity, and benefit. The ALJ's PFD aligns with OPIC's position, finding the petitioner demonstrated compliance with the applicable statutes and rules after considering evidence from all parties, including the city's concerns. Firstly, on project description and background, the proposed districts would serve a planned residential development in Grayson County, providing water, wastewater, stormwater management, and road infrastructure. The evidence showed the projects are necessary to support growth in the area. Secondly, as to availability of comparable services from other systems under Texas Water Code 54021B1, the City of Van Alstyne agreed it could provide services, but the petitioner demonstrated that the city's infrastructure is either not immediately available or comparable in a cost-effective manner. Comparable services from nearby municipalities or districts were evaluated and found either insufficient or unavailable. Thirdly, as to reasonableness of projected construction cost rate, tax rates, and water and sewer rates under Texas Water Code 54021B2, construction costs were shown to be reasonable and aligned with similar projects. Tax rates are projected at $1.50 per $100 valuation, which is reasonable compared to similar districts and supports bond issuance without undue burden. And water and sewer rates are set to cover operations and maintenance while remaining competitive. Fourthly, effects on environmental and physical factors under Texas Water Code 54021B3 did not show an unreasonable impact on land elevation, subsidence, groundwater levels, recharge, natural runoff, drainage, water quality, or total tax assessments. The ALJ concluded that the petitions meet all criteria with no rebuttal sufficient to overcome the petitioner's evidence, and OPIC is also persuaded that the petitioner met the burden of proof by a preponderance of the evidence. The petitions comply with all statutory and regulatory requirements, and the projects are feasible, practicable, necessary, and beneficial. OPIC therefore recommends that the Commission adopt the PFD and approve the petitions to create Grayson County Municipal Utility Districts at numbers 6A and 6B. Thank you. I'm available for any questions.
Thank you, Eli. Very thorough. I believe the applicant has, 3 minutes and 28 seconds remaining, if you'd like to use it.
Yes, Chairwoman, I may not use all of it, but I would like to address some of the comments that Ms. Albrecht raised. First of all, the MUDs that would be created here are designed to do exactly what the legislature intended. They're there to provide the services. They're there to build the wastewater plant. They're there to build the water infrastructure. In fact, we're drilling a water well as we speak now. We've already got our public water system authorization from TCEQ. With regard to the second point that Ms. Albrecht raised regarding the construction costs in 2022 when the petitions were filed versus construction costs in 2025 when the case was tried, there's a case in the briefing where the commissioners essentially have said in previous cases, we don't want to require the applicant and the executive director and everybody else to have to come back again and again and again and completely reevaluate all the costs, because this has been a 4-year process up to this point. And of course, those costs are different. But there is testimony in the record from our expert engineer, Mr. Jim Wiegert, and he said there is a difference, but it's just a little bit. So that issue doesn't carry any weight. With regard to the difference in the cost for us to build our wastewater plant and our water treatment plant, they are more than what the city said they could provide us those same services for. However, the record is full of evidence that we tried to get service from the city. We negotiated a comprehensive development agreement, and I will tell you in my experience that this development agreement had everything in it. But one of the things it did have in there is that the city wanted to annex our property. Or that didn't have in there, they wanted to annex our property. And for us to annex our property, it's an additional tax burden. It just didn't work for us. So the development agreement was so outside the bounds of what our project plans were, it wouldn't work. And if it would have been cheaper for us to get wastewater service and water service from the city, given all the factors that we have to consider, I promise you we would have done that. It didn't work. The city wouldn't agree to terms that were reasonable, that would comport with our project. With regard to groundwater levels, we did a study. We put a study from Collier Engineering into evidence that shows that they looked at our groundwater. They decided that the wells that we're going to use, the water will be available. Again, we're drilling a water well out there as we speak right now. In fact, there's no evidence that there would be subsidence or any impact on groundwater. And with regard to runoff rates, the test is whether the runoff would be different from substantially different from other developments. The record shows that the runoff rates wouldn't be any different from any other developments in the area. And in fact, we're going to spend $34 million to control runoff and drainage and another $5 million on detention facilities. So runoff rates are not a reason not to grant the petitions. And with that, Commissioners, I'm happy to answer any questions. We would ask you to approve our petitions.
Thank you very much. Any questions for Mr. Seal? All right. So colleagues, I've reviewed the record in the ALJ's PFD and proposed order and agree with the ALJ that the evidentiary record demonstrates that the districts are feasible, practical, necessary, and would be a benefit to the land included in the districts, and that the petition for the creation of the districts should be granted. I am ready to adopt the ALJ's proposed order with the addition of the ordering provision recommended by the ED and her exceptions and agreed to by the ALJ in his reply to exceptions. I also noticed a few other typographical errors in the ALJ's proposed order that should be corrected to ensure clarity and consistency with the ALJ's determinations. First, excuse me, I've got a bit of cold, y'all. I would replace the word water with wastewater in finding of fact number 32. Add the phrase changes in the to the finding of fact number 81. Add the word to finding of fact number 82. Replace the word can with cannot, it's kind of important, in finding of fact number 100. Correct the spelling of Claire Corona's name in finding of fact number 116. Conclusion of law number 13 and ordering provision number 6, and finally replace the citation to the Texas Government Code in conclusion of law number 5 with the Texas Local Government Code. I will stop and see what Katarina thinks. Tanya.
I'm in agreement.
I'm in agreement.
I'll make the motion. Thank you. I'll make the motion with the typographical changes. I move that we adopt the ALJ's proposed order as modified by his reply to the exceptions letter dated September 5th, 2025, and with the following changes. To correct the typographical errors in the ALJ's proposed order, A, amend the finding of fact number 32 to replace the word water with the word wastewater to clarify that this finding relates to the district's proposed wastewater facilities and infrastructure. B, amend finding of fact number 81 to add the phrase changes in the so that the finding states development of the district systems are not expected to cause changes in the overall land elevations other than normally associated with the construction of such systems. C, amend finding of fact number 82 to add the word to so that the finding states, based on the proposed improvements in topography of the land, the discernible impact to land elevation cannot be expected. D, amend finding of fact number 100 to replace the word can with cannot, to clarify that the ALJ determined an unreasonable effect or impact on flooding, natural runoff, rates, or drainage in the proposed districts cannot be expected. E, amend finding of fact number 116, conclusion of law number 13, in ordering provision number 6 to correct the spell of Claire Corona's name when being appointed as a temporary director. And F, amend the conclusion of law number 5 to replace the citation to the Texas Government Code with the Texas Local Government Code.
A second.
Thank you. All those in favor say aye.
Aye.
Aye. Motion passes. Thank you.
Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Lyondell Chemical Company for the major amendment with renewal of TIPD's permit number WQ 000292700. The applicant should speak first, followed by protestant, the ED, and then OPIC. The parties have been notified that they will each have 5 minutes for oral argument. Applicant may save time for rebuttal as it bears the burden of proof on the application. And with that, we have Whit Swift here for the applicant.
Good morning, Chairwoman Pop, Commissioner Gonzalez, Commissioner Miller, General Counsel Smith, Public Interest Counsel Arthur. My name is Whit Swift. My co-counsel, Sarah Bergen, and I represented Lyondell Chemical Company, the applicant in this matter, and who is seeking the permit that is before you today. Lyondell appreciates the work of the Water Quality Division in preparing the draft permit and reviewing its application, and appreciates the work of Kyle Lucas and his ADR team in attempting to resolve this dispute. The permit at issue in this matter is the Texas Pollutant Discharge Elimination System, or TPDES permit for Lyondell's Channelview South plant. The application seeks to authorize a number of changes to the permit, including the establishment of a new discharge limit for copper that is based on site-specific receiving water characteristics rather than the default assumptions made for the limit in the current permit. The application does not seek any increase to the volume or flow of wastewater authorized to be discharged under the permit. After reviewing the evidence presented during the hearing, Judge Johnson found that the permit complies with the TCEQ's anti-degradation policy and that the draft permit will be protective of the water quality, including the protection of human health, the existing uses of the receiving waters, and the protestant's use and enjoyment of his property. Judge Johnson's PFD recommends issuance of the draft permit as prepared by the Water Quality Division. No party filed any exceptions to the ALJ's conclusions. The only exceptions were filed by the ED seeking a change to one finding of fact to correct the dates that the TCEQ Executive Director declared the application administratively complete and technically complete. Lyondell appreciates your review of the record in this matter and respectfully requests that you issue an order issuing the draft permit, including the date corrections to the one finding of fact identified in the proposed order, and adopting the ED's response to comments. Thanks. I will reserve the rest of my time for rebuttal if necessary, unless you have any questions for me at this time.
No, thank you, Mr. Swift. We will hear with Douglas Stewart.
And he's virtual.
Oh, thank you. Mr. Stewart?
Hello.
Hello, Mr. Stewart. We can hear you.
Okay, good. Just a few comments I want to make here, and mean no offense to anyone, but through this process that we went through with Lawyer Smith and Judge Johnson and others, it became very clear to me. The reason I represented myself is because I thought I could. But it became very clear to me that our process that we have of dealing with these sort of things in the state of Texas, unless you hire an attorney, and I did consult with an attorney, and the fee was approaching $250,000, which I could not pay. But it became apparent to me in listening to the attorney's primary witness, which was not allowed to answer any questions throughout the system. The two supposedly experts that he brought in, one was supposed to study the hydrology and make an answer, and his expertise was in zoology. The two people presented by Ed from his office did not understand anything about hydrology or the only thing they understood was they were good report writers. And so I'm kind of ranting just a little bit, but I'm saying that the system that we have, and this is my primary reason for being here, the system that we have in place does not allow a citizen of the state of Texas to represent himself, because there's no way he can compete with the strength of a person like Whit Smith or any other attorneys that they would bring to this case here. And so I know that what I have presented 2 times over the last 20 years, and it still continues, and it's going to continue. Right now, I'm in the state of being treated for cancer, so I might not be here if it ever gets settled. But it's going to continue just simply because we do not have a system in place where a common, average, ordinary resident of the state of Texas within 300 feet of something that's happening can take it through the system and receive an acceptable response to it. And that's the main point I want to make, is that you got good people, you got a good system, but the system does not include those that cannot afford to hire very expensive attorneys. So this is not meant to be offensive to anyone, and I hope it hasn't been, but that's my reason for wanting to appear and make a few comments. And I thank you very much for that.
Thank you, Mr. Stewart. I appreciate your comments, and I'm sending you good thoughts and prayers on your journey with cancer. It's a terrible disease, so thank you. And we hear from the ED now.
Good morning, Chairwoman, Commissioner, General Counsel, Public Interest Counsel. For the record, my name is Cole Malley with the Environmental Law Division, and I'm here today on behalf of the Executive Director. With me today are ED staff Jenna Lug, Peter Schaefer, Matthew Kennington, and Monica Baez of the Water Quality Division. The ED respectfully requests that the Commission adopt the ALJ's order with the ED's exception and issue the permit. The Commission referred 2 issues for the contested case hearing. Issue A, whether the permit complied with TCU's anti-degradation policy pursuant to 30 TAC 37.5, and B, whether the draft permit's protective of water quality, including the protection of human health, existing uses of the receiving waters, and use and enjoyment of the requester's properties, in accordance with applicable regulations, including the Texas Surface Water Quality Standards and 30 TAC Chapter 307. ED's witnesses testified to these issues and addressed the permit's technical completeness and compliance with all applicable TCEQ regulations and statutory requirements. The protestant, Mr. Stewart, failed to rebut the presumption that the permit met all applicable statutory and regulatory requirements. Most of the issues Mr. Stewart raised in his arguments were outside the scope of what the Commission can consider as part of the wastewater permitting process. Mr. Stewart did not submit any substantive evidence that the draft permit did not comply with TCEQ's anti-degradation rules or the Texas Surface Water Quality Standards. Upon review of the evidence, the ALJ determined the applicant met its burden of proof, providing the draft permit complies with all applicable legal and technical requirements, and recommended the Commission issue the permit. ED followed the sole exception, and the ALJ agreed the Commission should adopt it. In summary, ED recommends the Commission adopt the order with our exceptions and issue the permit. Thank you. I'm here for questions.
Thank you very much. OPIC?
Good morning again, Chairwoman Pope, Commissioner Gonzalez, and Commissioner Miller, Executive Directors, Attorneys, and staff. My name is Eli Martinez with the Office of Public Interest Counsel. After reviewing the record, participating in the contested case hearing, and considering the evidence in the law, OPIC recommends that the Commission grant Lyondell Chemical Company's application for a major amendment with renewal of their TIPD's permit. Lyondell operates a petrochemical manufacturing complex along the Houston Chip Channel in Channelview, Harris County. The existing permit authorizes discharge of treated processed wastewater, utility wastewater, and stormwater into the Old River, which flows into the Houston Chip Channel. The company applied for renewal with a major amendment primarily to update monitoring requirements, adjust effluent limits to reflect current operations, and improved treatment technology, and incorporate newer standard permit conditions. One adjacent resident, Mr. Douglas Stewart, timely requested a contested case hearing, and the Commission referred 2 issues to SOA, as you've heard. relating to whether or not the draft permit will maintain existing uses and water quality in the receiving waters, and whether the draft permit is sufficiently protective of water quality and human health. Under Senate Bill 709 and the Commission's rules, the administrative record and the Executive Director's draft permit establishes a prima facie demonstration that the permit meets all statutory and regulatory requirements and will protect water quality, human health, and the environment. The ultimate burden remains on the applicant to prove its case by preponderance of the evidence, but the protestants bear the burden of going forward with evidence to rebut that presumption. After weighing the evidence, including Mr. Stewart's testimony and exhibits, Lyondell's technical witnesses, and the Executive Director's review, OPIC concludes, and the ALJ agreed, that the protestant did not present sufficient credible evidence to rebut the prima facie demonstration. The draft permit contains stringent numeric effluent limits for conventional pollutants, metals, organics, including benzene, toluene, and dioxins, whole fluent toxicity, and other parameters based on the latest Texas Surface Water Quality Standards, EPA criteria, and the Commission's 2018 implementation procedures. Chronic and acute whole effluent toxicity limits will remain unchanged. Updated monitoring frequencies and methods reflect modern analytical capabilities and actually increase oversight in several areas. The anti-degradation review confirmed no lowering of water quality and no adverse effect on existing uses, which are currently aquatic life, contact recreation, and industrial water supply. And Lyondell's compliance history and the facility's upgraded treatment systems support the conclusion that the permit will maintain water quality in Old River and the Houston Chip Channel. Mr. Stewart raised concerns relating to odors, health effects, and past incidents, but the evidence showed these issues are either addressed under separate air or enforcement authorities or not supported by the water quality data that is tied directly to this discharge. OPIC's review confirms that Lyondell met its burden on the two referred issues by preponderance of the evidence. OPIC accordingly recommends that the Commission adopt the proposal for decision and issue the major amendment with renewal of TIPD's permit number WQ000292700 as drafted by the Executive Director. Thank you. I'm available for any questions.
Thank you, Eli. Mr. Swift, you have 2 minutes and 41 seconds remaining if you'd like to use it.
The applicant, thank you very much.
Thank you. Well, thank you all for your presentations. I've reviewed the administrative record, including the parties' arguments and evidence, and I'm on the same page with the ALJ. The record supports that the draft permit is protective of water quality and meets anti-degradation requirements. I would grant the application, issue the permit, and adopt the ALJ's proposed order as revised by the ALJ's letter dated September 9th, 2025. I would also make a few revisions in the order to make sure that some of the information that is in the ALJ's PFD in the order, and to clarify the legal standard for the agency's anti-degradation review. To memorialize findings and conclusions regarding anti-degradation from the ALJ's PFD and Commission's orders, I propose that we add a new finding of fact 18A to state existing uses and water quality sufficient to protect existing uses will be maintained by the draft permit. The draft permit does not authorize any activity that would cause degradation of waters in the San Jacinto River tidal segment. And I would propose that we revise conclusion of law number 12 to state the draft permit complies with all applicable anti-degradation requirements, existing uses, and water quality sufficient to protect those existing uses will be maintained, and activities subject to the draft permit will not lower water quality by more than a de minimis extent in waters that exceed fishable or swimmable quality in accordance with 30 Texas Administrative Code Section 307.5. I'd also add an ordering provision that issues the permit. Colleagues?
I'm in agreement.
In agreement.
Thank you. Do I have a motion?
I move that we grant the application of Lyondell Chemical Company for a renewal and amendment of TIPD's permit number WQ000292700 and issue the permit in the form recommended by the Executive Director, that we adopt the Administrative Law Judge's proposed order as revised by the ALJ's letter dated September 9, 2025, with the following further revisions. A, to memorialize findings and conclusions regarding anti-degradation from the ALJ's PFD in the Commission's order, add new finding of fact 18.a to state existing uses and water quality sufficient to protect existing uses will be maintained by the draft permit. The draft permit does not authorize any activity that would cause degradation of waters in the San Jacinto River tidal segment. B, to more fully and accurately recite the legal requirements for anti-degradation, revised conclusion of Law 12 to state the draft permit complies with all applicable anti-degradation requirements. Existing uses and water quality sufficient to protect those existing uses will be maintained, and activities subject to the draft permit will not lower water quality by more than a de minimis extent, and waters that exceed fishable or swimmable quality in accordance with 30 Texas Administrative Code Section 307.5. C, finally, to clarify the Commission's intent to issue the permit, add ordering provision 1.a to state the permit is issued in the form of the draft permit as recommended by the Executive Director.
Do I have a second?
A second.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank y'all very much. We'll let everyone shuffle and then move on to item 3. Eli, I need a baby update. Okay.
Item number 3 is the consideration of the motion to overturn the Executive Director's issuance of Travis County Water Control and Improvement District Number 17's TLAP number WQ0013878001. The ED, who's the movant, should speak first, followed by the applicant. Currently, no one is registered for the applicant, however. And then OPIC in that order. The ED may reserve time for rebuttal as the ED bears the burden of proof. OGC recommends 5 minutes for each party, and the ED may reserve time for rebuttal, as I said before. So with that, we'll begin with the ED.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Michael Parr with the Water Quality Division. With me today is John with the Water Quality Division. I apologize, I just blanked on his name because I'm nervous.
John Hearn.
John Hearn.
It happens.
Yeah. The ED's decision at issue here was noticed to the public and mailed on September 30th, 2025, and was in error procedurally. The ED's approval of the application for a major amendment with renewal submitted by Travis County Water Control and Improvement District Number 17 was inadvertently not processed in accordance with state law, the Texas Administrative Procedures Act. The ED has determined that her decision to approve the application and to issue the draft permit was in error based on inaccurate information. Therefore, the draft permit's issuance does not comply with TCEQ rules, and the decision to approve the application and issue the draft permit should be overturned so that the ED may continue processing the application according to the TCEQ rules. The ED respectfully recommends that the Commission find that the ED's arguments for overturning her decision are with merit. Thank you. We are available to answer any questions.
Thank you. Any questions?
I just say, good job, you made it through it.
Yes, you did great.
You can only go up from here.
You're doing great, sweetie. All right. We will hear from, go for it, Mary.
Okay. If there's anyone here representing the applicant, no one was registered. So from there, we can go to OPIC.
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC understands that when this application was reviewed and the permit issued, a required step in the public participation process was inadvertently omitted. Specifically, a timely comment from the City of Austin was deemed untimely, and no response to comments was filed. We agree that a motion to overturn is needed so that the Executive Director may continue processing the application, and we respectfully recommend that the Commission grant the ED's motion.
Thank you, Garrett. Any rebuttal?
No rebuttal.
All right. Thank you. Before us is a motion to overturn filed by the ED to correct a procedural error in processing processing Travis County Water Control and Improvement District Number 17's application for Texas Land Application Permit Number WQ00138780001. Required public participation step was accidentally missed, so I agree with the ED that we should overturn the permit and remand it to the ED to continue processing the application in accordance with all applicable rules. Colleagues?
I agree.
I agree.
All right, do I have a motion?
I move that we overturn the executive director's issuance of Travis County Water Control and Improvement District Number 17's Texas Land Application Permit Number WQ00138780001 and remand the matter to the executive director to continue processing the application in accordance with TCEQ rules.
A second?
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you.
Could I just quickly say, I really appreciate the executive director's office correcting the mistake. Yeah.
Well said.
Item number 4 is the consideration of the petition filed by LH207LP for the creation of Williamson County Municipal Utility District Number 62. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank y'all very much. Before we get started, I'd like to say it's not lost on this commission that we're creating taxing districts. That authority, it's a big authority, and we regard that authority with the utmost gravity. MUDs are a very handy development tool, but they still can levy taxes on Texas citizens. The item before us is a municipal utility district creation matter proposed to be located entirely within Williamson County. The petition includes a request for road powers. For district creation matters, we look only at whether the hearing requester is entitled to a hearing. TCEQ rules require the commission to consider for governmental entities their statutory authority over or interest in the issues relevant in the application. Williamson County is the sole hearing requester, and the county's request raised relevant concerns about roads within the proposed district connected to the county's broad statutory authority over various aspects of roads. The request for road powers in the application requires the commission to consider the layout of road facilities, the petitioner's cost analysis, and the amount of bonds necessary for road facilities, and whether they are financially and economically feasible for the district. Given Williamson County's identified statutory interests that relate to their authority over roads within the district, I'd recommend granting the hearing request. And while I recommend granting the Williamson County's hearing request, I'd like to encourage the parties to work together to reach an agreement if possible, and I'd recommend this matter be referred to the Commission's ADR program to run concurrently with the SOA scheduling process. I'd also like to add a 180-day hearing duration from the date of the preliminary hearing until the PFD is issued so that this matter can move forth in an expeditious way through the SOA process. Interested to hear what my colleagues have to say.
I actually would like to have oral argument on these issues, and reading the backup and the briefing materials, I'm noticing some shifts, and with the new commission, I think we could all benefit from being more fully briefed. And so I actually would like to make a motion to bring this back for oral argument and the following item for the January 14th agenda.
I was actually going to ask for more time on this too, but I think the oral argument is a good idea. I think given the new-ish position of the ED's office staff, it would be beneficial for us to have more information.
I agree that more information is needed and more time. I do want to resolve this matter sooner rather than later because there are many entities waiting on this decision. So January 14th?
Could we not do January? Could we do December? Possibly. I will be out of the country January 14th, and I would like to be here for it.
When is the December agenda?
December 17th.
Let's move it to December 17th, please. That's enough time, I believe. All right.
I do think it's a little bit difficult with, Christmas travel and other travel, because it's not just our schedules, right? We're asking the parties to be fully prepared on that as well. So I would be good with even moving it to the January 28th. I know that I'm very sensitive to delays as well, but if we refer this over to SOA, you're talking about 6 months to a year, right? And in the meantime, I think the parties could also keep working towards an agreement.
Understand that. I would still like to have it in December. We have an agenda hearing for a reason, and people will be prepared, and they will get prepared, hopefully, and be able to present orally. And I need to have all three commissioners here when we hear and decide this. So, I move to move item number 4 to the December 17th commission meeting. Do I have a second?
Can we move 4 and 5?
I was just
Or, sorry.
5 isn't called, but
Do we have to do separate motions?
maybe, I guess, why don't I go ahead and just call 5 as well? And item 5 was the consideration of the petition filed by Florence FM 970 Ventures LLC for the creation of Northwest Williamson County Municipal Utility District Number 3. And then now that that's been called, we're on both.
Okay, thank you. I move to send items 4 and 5 to the December 17th commission hearing.
Second.
All those in favor say aye.
Aye.
Aye. All right.
So item 6 is the consideration of the petition filed by Sunny Jane Elizabeth Ahrens and Thomas Edward O'Kelly for the creation of Kelly Farms Municipal Utility District of Johnson County. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in, I'll note on this one, we do have Representative Kerwin signed in on this, and they will all be noted for the record.
Excuse me. This item is very similar to our last item, and it involves another petition for the creation of municipal utility district in Williamson County. Given the fact that it is very similar to items 4 and 5, I would like to move that it be added to the December 17th commission meeting as well.
I'm fine with that.
That's fine.
Yep. All right. I move that we send item number 5 to the December 17th commission meeting.
Second.
All those in favor say aye.
Aye.
Aye. All right. Thank y'all.
Oh, instead of December 17th.
17th.
Oh, I'm sorry. Oh, I'm sorry. So to clarify, that was on item 6, the current item that we're on.
Oh,
You
I'm
said
sorry.
item 5.
Thank you.
Everybody on the same page on that one?
Yes.
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 Yes. Okay, thanks. Item number 7 is the consideration of the application by the City of Abilene for renewal of TIPD's permit number WQ005213000. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
I'll let everyone have a chance to sit down. All right. Item 7 before us is the application by the City of Abilene for renewal of its TIPD's permit to authorize the discharge of water treatment waste at an annual average flow not to exceed 1,510,000 gallons per day in its final phase into Possum Kingdom Lake. The Commission received numerous hearing requests and requests for reconsiderations on this matter. For this type of renewal application, however, the Texas Water Code Section 26.028 states that there is no right to a contested case hearing if, 1, the applicant is not applying to increase significantly the quantity of waste authorized to be discharged or change materially the pattern or place of discharge. 2, the activity to be authorized by the renewal permit will maintain or improve the quality of waste authorized to be discharged. And 3, any required opportunity for public meeting has been given. 4, consultation and response to all timely received and significant public comments has been given. And 5, the applicant's compliance history for the previous 5 years raises no issues regarding the applicant's ability to comply with the material term of the contract. Excuse me. I agree with the ED, OPIC, and the applicant that all 5 conditions for no right to a hearing on this application are clearly met, so I would deny hearing requests. Colleagues?
I'm in agreement.
In agreement.
Thank you. Next, I find that the requests for reconsideration don't bring new relevant, new material information for the ED to consider and are duplicative of the hearing requesters' issues raised during the comment period, so I recommend that we deny the reconsideration requests. I'd also grant the renewal of the TIPD's permit number WQ005213000 to the City of Abilene and adopt the Executive Director's response to comments.
In agreement.
I agree.
Thanks. Do I have a motion?
I move that we find that no right to a hearing exists on the application, that we deny all hearing requests and requests for reconsideration, that we grant the renewal of TIPD's permit number WQ005213000 to City of Abilene as recommended by the Executive Director, and that we adopt the Executive Director's response to comments.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Thank you. Motion passes. Thank y'all. Excuse me.
Item number 8 is the consideration of the application by Mustang Springs Utility LLC and Jaffe Interests LP for new Texas Pollutant Discharge Elimination System permit number WQ001-652-4001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right. Before us for consideration is application by Mustang Springs Utility LLC and Jaffe Interest, Jaffe? Are we? Yeah, okay. Interest LP for a new TIPD's permit to authorize a wastewater discharge of 990,000 gallons per day in its final phase. We received several requests for hearing and reconsideration in this matter. However, yesterday evening, we received notice that Mustang Creek Ranch had withdrawn its hearing request. Based on the nature and size of the proposed discharge, the interest raised by the remaining requestors, and the location of those requestors, I would deny all hearing requests, as well as the request for reconsideration. I would further propose that we grant the application, issue the permit, and adopt the ED's RTC.
I agree.
I agree.
All right, do you have a motion?
I move that we deny all hearing requests and requests for reconsideration, adopt the Executive Director's response to comments, and issue the draft permit as recommended by the Executive Director.
Have a second? All those in favor say aye.
Aye.
All right. Item number 9.
Item number 9 is the consideration of the nomination and appointment of 7 individuals to the Tax Relief for Pollution Control Property Advisory Committee, and the Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Melissa Altman with the Air Quality Division. With me is Amanda Cranach with the Environmental Law Division. As described in Section 11.31 of the Texas Tax Code, TCEQ is required to establish a permanent advisory committee to advise the Commission regarding the implementation of the Tax Relief for Pollution Control Property Program. The committee consists of 13 members. 7 of those members' terms end on December 31st, 2025. Commission approval is required for the appointment to the vacated committee positions, which include 3 industry representatives, 2 appraisal district representatives, 1 taxing unit representative, and 1 independent technical expert. Notice of the vacancies was published in the Texas Register, posted on the TCEQ website, and sent to GovDelivery subscribers to solicit applications. The submitted applications and the Executive Director's recommendations for appointments to the positions are presented today for your consideration. These appointments will serve a 4-year term. We thank you for your consideration of this matter and are available to answer any questions.
Thank you very much. Any questions? Okay. All right. Mary, has anyone signed in on this item?
No one has signed in on this one.
Right. OPIC, Garrett?
OPIC supports the resolution to appoint 7 new members to the Tax Relief for Pollution Control Property Advisory Committee.
Short and sweet. Thank you. I'd like to thank staff for the work that went into soliciting nominations and evaluating them. And I'd also like to thank all the members of the Tax Relief for Pollution Control Property Advisory Committee for their service and participation in this advisory committee. We're checking on it, but if I can attend legally, I plan to attend the next, their next commission meeting. I'm prepared to move forward with the nominations as the ED recommends. Colleagues?
I agree, and I want to thank everyone for their willingness to serve.
I agree.
All right, do I have a motion?
I move that we adopt the proposed resolution appointing the following individuals as members of the Tax Relief for Pollution Control Property Advisory Committee to serve 4-year terms expiring on December 31st, 2029. Bob Adair as a representative from industry, Charles Allred as an independent technical expert, Michelle Carter as a representative from industry, Karen Kahn as a representative from appraisal districts, Martha Landwehr as a representative from industry, Bill Longley as a representative from taxing units, and David Popular as a representative from appraisal districts.
Do I have a second?
A second.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. Great job, ladies. All right, that brings us to the enforcement docket, items 10 through 22.
So items 10 through 22 are before you for your consideration, and the executive staff, or director's staff, is here to present.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Melissa Cordell, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 10 through 22. The total assessed administrative penalties are $456,005, with $82,507 deferred. $91,113 applied towards supplemental environmental projects, $282,385 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thanks, Megan. Mary, do we have anyone signed in on this on these items?
So on items 12, 13, and 15, there are individuals who are signed in and available to answer questions. And then on item 21, we have Austin Hines England who would like to address the commission.
We will take up Austin first on item number 21.
And he is virtual.
Austin, are you there?
Yes, can you hear me now?
I can hear you.
Yes, my only request to be heard was if y'all needed to hear anything from me. So with that, I will yield my time back to the panel.
Goodness, thank you very much. I appreciate it. Do we have any questions for those who are here for 12, 15, and
13.
12, 13?
Yeah, 13 and 15.
13 and 15. Nope. Nope. All right. Garrett?
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Thank you. I'd like to thank enforcement staff for all their work that went into preparing these orders for us today. I'm prepared to move forward with adoption. Colleagues?
I agree.
Agree.
All right. Do I have a motion?
I move that we adopt items 10 through 22 as recommended today by the executive director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Thank you. The motion passes. Move on to our monthly enforcement report, number 23.
And the executive director staff is here to present this one as well.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Megan Hamilton of the Enforcement Division, and with me today are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2026 through September. There were 181 effective administrative orders issued, and of those, 22 contained supplemental environmental projects. These orders assessed a total of $4,554,251 with a payable amount of $2,457,620. $1,370,922 are to be paid towards supplemental environmental projects. 1,258 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 132 enforcement action referrals have been received. There are 3,260 pending administrative orders with 1,447 cases that are on the backlog. 164 cases are pending at the Attorney General's office for representation in district court, and 0 judgments have been issued. 1,618 cases are being tracked for compliance. We're able to answer any questions you may have.
Thank you very much. Any questions for executive director staff?
No, just thank you for the report.
Has anyone signed in on this order, on this item?
No one has signed in.
All right, OPIC?
OPIC has no comment except to say that we appreciate staff's report.
Thank you. Again, I appreciate the report and all the efforts of OCE. To my fault, I was going to congratulate the new head of OCE. Chrissy Mills Juruk took over, and she's doing a fabulous job. So I would like to announce that she is taking that role, and we're very, very proud of her. Colleagues?
Happy to have her.
Congratulations. Thank you for the report. No action is required on this item. All right, Mary, next item.
The next items are for closed session. The commission will meet in closed session in room 4222 of Building F, beginning at approximately 10:45, 10:50, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 074, to take up and consider matters pursuant to items 24 through 27 as posted and noticed.
Thank you. This meeting stands in recess.
The commission met in room 4222 of Building F for closed session from 10:58 a.m. until 11:57 a.m. on item numbers 25 through 27, as posted in notice pursuant to Texas Government Code, Section 551074, as posted in notice. No action was taken. The agenda stands adjourned, and the time is 12:09.